Hello, my name is David Winch and I'm a forensic accountant with Bartfield's Forensic Accountants. And in this 30-minute session or so today, we are going to be looking at the section 16 statement in confiscation and the benefit aspects of that statement. We're not going to cover available amount, we're not going to cover default sentence and a few other things that also appear in the section 16 statement, because we just couldn't squeeze out all of that into 30 minutes, and I didn't want to go over time. So let's look at the agenda. What is a section 16.3 statement of information? How does confiscation differ from a trial? Then we're going to look at the benefit of particular criminal conduct. Moving on then to assumed benefit. And then finally, other benefit which is neither benefit of particular criminal conduct nor benefit which is assumed benefit under the statutory assumptions. And finally, just a quick word about how Bartfield's Forensic Accountants can help in confiscation and indeed in other criminal and civil legal proceedings. Okay, so what is a section 16 statement of information? I've put section 16 subsection 3 and the reason for that will become clear in a minute, but basically we usually refer to these as section 16 statements. It's a document which is prepared by the prosecution. It's usually written by an accredited financial investigator on behalf of the prosecution. And it is served on the court and the defendant. It takes into consideration the defendant's response to the earlier proceedings, usually the first step, or one of the first steps in a confiscation, is for the defendant to be subject to a section 18 order, which is an order and a questionnaire requiring information from him. And that information, assuming that he does supply information, that information is taken into account by the AFI in preparing the section 16 statement. And the section 16 statement sets out the prosecution's position in relation to the defendant's benefit and also covers his available amount, including in relation to benefit, of course, and in relation to available amount, including whether he has a criminal lifestyle. And I say also in relation to available amount because that affects things such as tainted gifts. And the section 16 statement does provide certain other information relevant to the confiscation proceedings. But as I say, we're actually not going to go there today. So the section 16 statement, let's be clear, it's a statement which is not a written statement in the sense that that term is used in section 9 of the Criminal Justice Act 1967. So it's not a witness statement in that sense. And it does not require a declaration by the author that it is true. It doesn't have a declaration of truth, which of course is so standard. We see that all the time. The very first thing in the section 9 statement is the declaration of truth. That is not there in a section 16 statement, because a section 16 statement isn't that sort of a statement. It's not limited to purely factual material. And it's not limited to information which would be admissible at trial. It can go beyond that. So you can have stuff in a section 16 statement that would certainly not be admissible at the defendant's trial. It may include assertions of disputed facts or disputed inferences, and it may include estimated figures. It may also include legal arguments for the court's attention. And it is usually supported by voluminous appendices of documents and materials. In fact, if it's not supported by voluminous appendices, then there's probably something that ought to be there that isn't. So it's not a witness statement, it is a statement of information. It is much broader in its meaning than a witness statement. As I say, not limited to factual material, not limited to admissible material, may have all sorts of assertions in, all sorts of inferences drawn by the author, estimated figures, legal arguments, the kitchen sink. It can all go in a section 16 statement. It is, if you like, the prosecutor's first attempt to discharge his obligations in relation to the confiscation proceedings. So how does confiscation differ from trial? Well, the focus, of course, in the trial is whether the prosecution can prove the defendant to be guilty to the criminal standard of one or more of the offences of which he is charged. That is what the trial is about, guilty or not guilty. The jury are going to decide, assuming it's a Crown Court jury trial, the jury are going to decide and they're going to give a yay or nay. It is, in a sense, as simple as that. What about sentencing then? Well, the focus in sentencing is likely to be on things like the harm done by the offences which have been proved, the culpability and role of the defendant, his previous convictions and personal history, his mitigation, whether he pleaded guilty, and if he did plead guilty, at what stage did he plead guilty, and how much a discount, if you like, to use that word, should be given in sentencing for that. All of these things are quite different from the focus in confiscation, because in confiscation, we're going to be looking at the benefit obtained in terms of property, so an asset of some sort, something of financial value when I say benefit, a benefit obtained by the individual defendant from his criminal conduct. And remember that whilst in a trial you can have several co-defendants all appearing at once, confiscation is all about an individual, just one person. And his confiscation may result in an outcome quite different from that of the co-defendant who stood next to him in the dock during the trial. And that benefit, of course, may include actual benefit, may include assumed benefit of his general criminal conduct over an extended period where he's got a criminal lifestyle. So the period of time that you're looking at in confiscation is not the indictment period. If there's a criminal lifestyle, you're looking at what is likely to be a much longer period than perhaps the indictment period was. And of course, in confiscation, we're also looking at the available amount of the individual defendant. And again, let me stress, an individual defendant. So it is, in fact, quite a different proceeding from the trial which went before. Okay, let's talk a little bit about the particular benefit, as it's called, the benefit of the offence or offences of which this defendant has been convicted. We're going to refer back to the indictment, of course, because we need to identify the specific offences of which he has been convicted. And this is one reason why I always expect to see a copy of the indictment appended to the section 16 statement. Don't always find it there. I always expect that it should be there, because it's the indictment that we need to look at when we're considering the benefit of particular criminal conduct, as it's called. The benefit of particular criminal conduct cannot be wider than the offence. And there was a case a year or two ago, which is listed there, which caused a bit of a stir. And the reason that case caused a bit of a stir is that the indictment on that occasion was not particularly well drafted, and it referred to, although it was a continuing offence, a failure to act over an extended period, the indictment was drafted in such a way that it referred to a failure on a specific day, just one day. And in confiscation, it was held that the benefit of the offence was limited to the benefit relating to that one day, even though it was common ground that the offending had spanned a period of years. That wasn't a particularly welcome development by the prosecution, or indeed by most people. And so the Court of Appeal looked at it again in a subsequent case, and it said this, that when we're identifying the offence, the court should have regard to the underlying legislation and to the statement of facts, so that where it is clear that the offending is alleged to have occurred over an extended period of time, and the defendant is well aware that that is the allegation that he is meeting, then the benefit also in confiscation will relate to that period of time as a whole and not to a single day. But it does mean that the prosecution have to be a little bit careful in how they word the indictment, just to make sure that they don't create a problem for themselves unnecessarily by limiting themselves by a badly worded indictment. So the case of Cameo in 2021, this year, kind of rolled back the decision in 2019 a little bit. Remember as well that benefit, when we talk about the benefit of the offence, we talk about benefit obtained as a result of or in connection with the offence. You shouldn't go overboard with in connection with. It shouldn't be interpreted too broadly. So that the case of James and Blackburn in 2011 revolved around smuggling imported tobacco, and as part of the importation, the offenders purchased cardboard boxes in which to place the tobacco. And the prosecution said at confiscation that the cardboard boxes were benefit obtained in connection with the offence. Court of Appeal threw that out. It said, no, they weren't obtained in connection with the offence. They were perfectly legitimate purchases, perfectly lawful purchases of cardboard boxes. Okay, they were purchased for the purpose of the subsequent offending, but they were not obtained in connection with that offending. So the value of the cardboard boxes was not part of the value of the particular benefit of the offences. So there are a few wrinkles and a few nuances in relation to particular benefit there. You may need, or the prosecution may need, supporting valuations, for example, drug valuations, where there is, where drugs have been seized, for example, there might be an appended valuer statement. Now, again, this is one of those areas where possibly at trial, the value of drugs may not have been a key matter to be resolved by the court. But in confiscation, the how much question, if you like, is the focus. So the valuation will be necessary in confiscation. Be a little bit careful of the sort of valuation that goes along the lines of Mr. Smith was arrested and he had on him 20 grams of cocaine. If we assume that that was one day's sales, and if we assume that he'd sold that much every day for the previous 6 years, then the total value is blah. Well, let's not make those assumptions. The burden, the initial burden, is on the prosecution on the balance of probabilities, not to the criminal standard certainly, but on the balance of probabilities to show that benefit exists. And pulling figures out of the air and thinking of a number is not the proper way to proceed. The burden of proof, as I say, is on the balance of probabilities. It is on the prosecution to satisfy the court of the amount of benefit obtained by the defendant. And one area where you can get some useful information in some cases is the sentencing remarks. If the judge has said in sentencing, Mr. Smith was clearly involved in this drug trafficking over a period of 3 years, let's say, then that is going to be a fact found at the trial by the court, and it's a fact then that can be used in the confiscation proceedings. But if there's nothing along those lines, then the prosecution are going to need some sort of evidence, some basis on which to persuade the court on the balance of probabilities of the amount of the particular benefit. And when I'm talking here on burden of proof, perhaps I should make clear that we are talking here of the particular benefit. It's a little bit different when we come to assumed benefit, but we'll get to that. The benefit may need to be uplifted or may be uplifted for changes in the value of money. In fact, section 80 does say it ought to be, in effect. And so there should be a table of the national CPIH statistics and a computation, which again one would expect to see appended to the section 16 statement. There may, of course, be benefit which has been obtained jointly, either with co-defendants or with perhaps with people who haven't been identified or haven't been brought to justice. As we've said, the confiscation proceedings relate to an individual. To be perfectly accurate, they can also relate to a company, which is a defendant, if the company has been convicted of an offence. But they do not relate to, let's say, if there's been a conspiracy, they don't relate to the whole of the conspiracy. They relate to the benefit obtained by this person who is now subject to confiscation. Where benefit has been obtained jointly, then the position is that the defendant obtains 100% of the benefit jointly obtained by him. But enforcement is limited in the sense that the amount required to be paid by all of those defendants who are subject to confiscation in respect of the same jointly obtained benefit, the amount that they're paying in respect of the jointly obtained benefit between the lot of them mustn't exceed 100% of that jointly obtained benefit. It may be that one particular defendant pays the whole 100%. That's fair enough. But you can't have two defendants each paying 100%. So, for example, if myself and my brother go and steal a painting that's worth £100,000, then we have jointly obtained a benefit of £100,000, haven't we? But we can't both be required to pay £100,000 under confiscation orders. We both have a benefit, we each of us have a benefit of 100,000, but the recovery by the Crown is limited to £100,000 in total from the pair of us. Let's talk about assumed benefit. Slightly more complicated. First thing to note is that it's not obligatory for the prosecution to pursue all possible benefit. And indeed, it is very common for the prosecution to say, for example, that they have not asserted any benefit of, let's say, expenditure. And the reason they've done that is perhaps because they want to avoid the risk of double counting and so on and so on. That's perfectly fair. The prosecution can pick and choose what assumed benefit they want to pursue. And so there is a certain amount of pragmatism involved in choosing what it is they're going to pursue. But where the prosecution does satisfy the court of any assumed benefit, the court is not permitted to pick and choose whether it accepts, whether it does anything about that assumed benefit, whether it puts that assumed benefit into the computation of total benefit. The court has no discretion there. The court cannot disapply the statutory assumptions because it doesn't feel like it. The only way it can disapply the statutory assumptions is if there would be a serious risk of injustice if the assumption were made, or, and in a sense this is not disapplying, if the assumption is proved to be false, then it's not applied. Do check, if you're acting for the defence, that the relevant day is correctly identified and explained in the section 16 statement, especially where proceedings for the offence concerned, and that's a term that is defined in the Act, where proceedings for the offence concerned, meaning the one or more offences which have triggered the confiscation proceedings, were commenced subsequent to other charges which did not result in conviction. And do be careful if the defendant has been subject to a previous criminal lifestyle confiscation order within the 6-year period ending on the date on which the current proceedings commenced. Because you're at risk, if you just go back 6 years from when the current proceedings commenced, you're at risk of an overlap with a previous criminal lifestyle confiscation, and that can't be allowed to happen. So in those circumstances, the relevant day becomes the day on which the previous criminal lifestyle confiscation order was made. And so is a period of shorter than 6 years. Where the prosecution are relying on property transferred to the defendant after the relevant day, and we're talking here, aren't we, about credits to bank accounts and so on, ensure that the property is transferred to the defendant solely or jointly, or that inclusion has been justified by an argument for piercing the corporate veil or something like that. Copies of bank statements and any spreadsheets relied upon by the prosecution hopefully are going to be appended to the section 16 statement. Hopefully they're all going to be there for you. And demonstrably legitimate receipts should be excluded because here the statutory assumption has been shown to be false. It's been rebutted. Also excluded, of course, should be transfers between the defendant's own accounts, transfers from the defendant to the defendant, because they are not transfers to the defendant because they were his money beforehand, and contra entries such as banks, debits, and so on. Sometimes you will find that the section 16 statement, the AFI preparing the section 16 statement, sweeps all this stuff in willy-nilly. In which case you've, from a defence point of view, you've got to weed it out and reject it. Where the prosecution are relying on property held by the defendant after the date of conviction, there should be appended to the section 16 statement copies of relevant documents showing ownership solely or jointly by the defendant, copies of relevant valuations, where there is a demonstrably legitimate interest of a third party, that should be excluded. But do be careful if that interest by the third party has been obtained by way of a gift from the defendant, because then you've got tainted gift issues and you've got problems there. Where the prosecution are relying on expenditure incurred by the defendant after the relevant day, ensure that that expenditure has been incurred by the defendant solely or jointly, or that the inclusion is otherwise justified by piercing the corporate veil or whatever. Again, copies of documents relied upon, receipted invoices and so on should be appended. So we're talking about a situation here, aren't we, where, for example, our defendant has purchased a motor car, apparently paid cash. There's no evidence of where that money's come from. The prosecution will then say that expenditure will have been funded, or is assumed to have been funded, by benefit of his general criminal conduct. So there should be some documentary evidence in support of that. And in all cases, exclude items already included under another head. Don't allow the same thing in twice. The benefit, again, in assumed benefit, can be uplifted for changes in the value of money. Now, what about other benefit? Well, where the benefit of previous criminal convictions can be established on a balance of probabilities, that benefit can be included within the benefit of general criminal conduct, where the defendant has a criminal lifestyle. This is because his benefit of general criminal conduct is the benefit he obtained from criminal conduct since the day he was born. It's not limited to the 6-year period since the relevant day. So if he's got old convictions from which he's had a benefit, then that benefit can drop into his benefit of general criminal conduct in the current confiscation proceedings. It doesn't often get included. And of course, from a defense point of view, if it's not included, it's not there, fair enough. Where the defendant has been subject to one or more previous confiscation orders, the benefit found under those previous confiscation orders should be included within the benefit of the defendant's general criminal conduct in a criminal lifestyle confiscation. So in effect, if 10 years ago, Mr. Smith had a benefit of £10,000 in a previous confiscation order, then if he's subject to confiscation again today, that £10,000 benefit comes in again, gets included in today's benefit of general criminal conduct if he has a criminal lifestyle in the current proceedings. But a deduction is then made from his total benefit equal to the amounts he has previously been ordered to pay. Not his previous benefit, but the amount he was previously ordered to pay under the earlier confiscation orders. So Mr. Smith has a benefit of £10,000 from a confiscation order 10 years ago. At the time, he was ordered to pay £1,000 because that's his available amount. There is £9,000 in relation to that old confiscation order, which he has never been ordered to pay. Then that £9,000 of benefit is going to drop into today's criminal lifestyle confiscation. In effect, the 10,000 drops in less this £1,000 deduction that he was ordered to pay previously. Where the defendant has previously been subject to a criminal lifestyle confiscation order, then that in effect draws a line. And in a new criminal lifestyle confiscation, you cannot look for benefit prior to the date of that criminal lifestyle confiscation order, which was missed at that time. If it was missed at that time, it's been missed and it can't be brought back. There's statute in support of that. Again, these points don't often arise, but if they do, you want to be sure that they've been correctly dealt with in the section 16 statement. Hopefully the section 16 statement will have a summary table of the defendant's total benefit, and that will be a useful thing to to hang your hat on to make your response to. As we've said, where the defendant has obtained benefit jointly, details should be provided within the section 16 statement, because you are going to need to be able to identify, insofar as you can, with whom that benefit has been jointly obtained. So you're going to need to identify which benefit was obtained jointly and with whom. And it might be convenient to include a table in the section 16 statement of the jointly obtained benefit, showing the value of each benefit jointly obtained and, insofar as it's known, with whom that was jointly obtained. Okay, we've come to the end of our 30 minutes. Let me just wrap up by reminding you that Bartfield's Forensic Accountants is part of the Sedulo family of companies, which offer a full range of financial services for businesses and individuals. We undertake legally aided and privately funded criminal and civil forensic accountancy work, and we have a team of experienced and highly trained accountants, analysts and support staff using the latest IT facilities, which are particularly useful, for example, for dealing with masses of bank statements and so on that you sometimes get in confiscations. We operate from offices in Leeds, Manchester, Liverpool and London, and the sort of work I'm talking about is usually based somewhere in England and Wales. The Scottish jurisdiction, the law in Scotland, is a little bit different, and we tend to focus our work in England and Wales. You can find more on this topic on our website. The address is there, and this and the previous webinars in this series can be found under the seminars section of the website. If you've got any questions or require any more information, do not hesitate to contact me. The best way to do that is by email. My email address is there on the screen, and we will send you out a copy of this webinar so that you can view it again at leisure, and also we will send you the slides. Thank you very much for your time. Thank you for being with me today, and we will see you again in a fortnight. Thank you very much. Bye.